All right, I screwed up. I'll take the full blame. Always, always, when I opened it up, it was number 2. All right. Can both of you hear me?
Yes, sir.
All right, ma'am, I'm assuming you can, but you're on mute, so I can't tell you for sure, so. This is 22-3408 DM, Bauma versus Bauma. Both parties are present via Zoom. This was father's motion regarding custody and for payment on house proceeds. There was a judgment of divorce just entered the 1st of April, pretty much. And since that time, father says there's been a change of circumstance. Mom moved 90 miles away, and that's, she's still within her rights, but she, I think, sir, you're saying that she's changed schools, and with joint legal custody, ma'am, you can't change schools without a hearing unless he agrees to it. There's also a motion for payment of house proceeds. I'm not sure that I know exactly how much should be paid, but it clearly looks like you were supposed to split proceeds, and it hasn't been done yet. Does that pretty much state what you're seeking, Mr. Bauma?
Yes, Your Honor.
Ma'am, what's your response?
False.
False what?
Well, that's what he's trying to come after me for, but, and as far as schooling went, I went down there to file a motion for that, and the lady there, the clerk lady, even had her ask her supervisor, because my lawyer did tell me I need, for that, I would have to possibly go to court for school choice, for change school districts, and so I went down there to do that, and also to, file a, what's it called, for him too, for other things, and she told me I didn't have to. That's when I told her my lawyer told me that I might have to, though. She went, so I said, could you make sure with your supervisor? So she walked back.
I don't even know who you're talking about, because clerks can't give you that kind of advice. All I can tell you is by law, you cannot change a kid's school district without, when the both of you have joint legal custody. If he disagrees and you want to change, you can't change until I allow you to change, which means the girl has to continue to attend where she was.
She wasn't the clerk. She was a lady that when you file for these orders, this to go to court for, it was them. And then the one that you go downtown into the court,
I have no idea who's telling you that. All I know the law. I don't know who's telling
I'm
you.
not saying you're right. I was just saying I tried doing it. I thought I had to too, but then when I went down there to do it, I was told I didn't have to.
Well, that's wrong. You cannot change school districts unless Mr. Bauma agrees. I mean, the two of you can always agree on stuff, but if he doesn't agree, and he doesn't, then the child will continue to attend, what is it, Thornapple Kellogg? Is that where?
That's where she was, but we are not in district. Neither one of us. That was the arrangements, as if we were both living there in our court papers, but neither of us are living in Middleville now. So we don't qualify even for her to attend. I wouldn't be able to get her there, as I am here now. And I asked him, though, in the beginning, I have text to prove it and everything. I tried conversating, talking about switching schools, because neither of us
were. If you guys can't agree, then I have to do it. It doesn't matter whether he agrees or, you say, I'm trying to work with him. It doesn't matter. Okay. The bottom line is, how can she not attend Thornapple Kellogg if that's where she was attending?
I'm not in the area. I don't live there. I'm the one taking him to school and back.
Sir, can she even attend Thornapple Kellogg?
She can, and I had her enrolled there in early July through school of choice, because I live in Caledonia, which is about 15 minutes from Middleville. And I had all that stuff set up with TK Middle Schools. I have emails with the staff there stating that she was good to go. And that was July 10th when I from Middleville. And I had all that stuff set up with TK Middle Schools. I have emails with the staff there stating that she was good to go. And that was July 10th when I emailed and inquired about making sure that she would still be able to attend there. For the main reason, because she's a junior, and I just wanted, this is a crucial point in her life.
Yeah.
But
if she can attend there, and she was attending there, you can't take her out of there unless I tell you you can, and I'm not, I gotta have a hearing to say that.
Okay,
Yeah.
I didn't, I went there to do that and that's when I was told that. So I didn't know what, I was just doing, I understand what you're saying. I guess.
I'm not even holding you. I'm not saying you didn't, okay? All I'm telling you is the law that she has to attend Thornapple Kellogg until I tell you you can move, unless Mr. Bauma, you can move any place you want. You just can't move the child.
So that's the other thing with that. Mr. Bauma wasn't present for the kid's life and active in the kid's life either during this time of decision. He was not visiting,
Yeah.
doing his.
This is
Patient-
what the law says. You have joint legal custody, okay?
Mhm.
All decisions that are made that have substantial effects on the kids have to be agreed to. If not, then I have to have a Lombardo hearing is what it's called to determine what is appropriate. I could decide that the child should attend, I don't know where you live, but I can't do it here because I gotta have evidence to see where it's appropriate, including best interest and all this kind of stuff. Until then, she has to attend Thornapple Kellogg until I allow it to move, and I can't do it on a Friday morning. I have to have an evidentiary hearing, and the evidentiary hearing, you guys should have figured this out before that you were fighting, because it's not gonna happen for 2 months. And until then, she's responsible to be attending there. You can move anywhere you want, but the child stays at the school.
Okay, so that's the problem too, is she's in the school now because of what I was told there when I went down to file.
I don't
didn't
care
like-
what you were
I don't-
told
I know-
there.
And that, but she's already pulled out now, so now it would be technically school choice. I would file an application for my
But
middle.
that's like saying that I violated the law and now I'll just have to go along with it until some other time. If Mr. Bauma is saying to me that she can go to school there come Monday, she has to go to school there come Monday. If they won't allow her there, then that's something different. But he is saying that she is to go to school there.
He can't get her there.
What do you mean he can't get her there?
He won't be able to get her there. That was part of our issue back then too, is why the custody was the same. He can't get her. It's school of choice. He's not in district. Buses don't tend there. So he would have to be responsible for picking her
So
up.
what you're saying to me is you can move anywhere that you
No,
want and take the child and just, that I win because I take the child.
no,
And
Not
now
what
he can't get her to school. So I just take her and force him into that.
no, he wasn't able to do it before, even. In the past, he wasn't active to be able to do anything when he didn't have a license for
You
a while.
guys just ended up divorced 4 months ago. All right.
Yes.
Yeah.
Until then, I don't know what your situation was, but you were married. All right. So all I'm saying, sir, take your hat off. All I'm saying is that I can't change a school without having a hearing unless you guys agree. So she has to go to Thornapple Kellogg. You're telling me what?
She's not in there no more.
That's because you did it illegally.
Yeah, but I didn't know that because I tried, I
So
thought.
what? I'm telling you, send her back. Thank you. And then we'll have a hearing.
So it's good. Okay, so now I have to send an application for school choice and it's gonna take a while. And I have to have transcripts again. I'm sorry, I thought I was doing the right way. I went down there to file this, thinking
Mr.
that I
Bauma,
had
how
to,
do you expect to fix this now?
me?
I just asked Mr. Bauma.
Oh,
Well,
sorry.
I was hoping that Mackenzie could just live with me during the school year so she can finish her last 2 years at Thornapple Kellogg. And I have a way to get her to school. I have close friends of mine that live in the Middleville School District that they've agreed that I could drop her off to their house on my way to work in the morning at 5:30, and she can take the bus from their house because
I'm just asking you, do you think that is really the best interest of your child?
absolutely. For her mental and emotional and
Where's she going now?
Edwardsburg,
And it's been for like 1 week?
yes. And it's good, what she wants to go for a career. It's got for sports wise, what she's going to school for. It's everything. It's got
Oh.
district.
you did get the approval for her to play softball this year? Because I was last understood she was gonna have to sit out a year.
And if she goes to school of choice for Middleville, she will too.
No, she won't. She was already at Middleville last
That
year. She
District. Yeah, but she was there she lived there.
never
District.
left school though.
She did.
I already asked you, I already had confirmation from the athletic director that,
But I
Yeah.
also have of when you do have them, you're not taking care of them. And I have
I'm not
comments too.
changing parenting time or anything. I'm just saying she has to go there until the time comes. If you guys have to work something out to get her there, then you have to work something out to get her there. I can't just change it here today. And I think, you keep saying somebody down there told you. I don't know who even told you, who told you that. I have no clue.
I mean, I got the paperwork filed to send him papers. If she's on that paperwork, I mean, that's who told me. Like, I am frustrated because like I tried doing it right, and here I am because
Well,
they told me I didn't have to.
Why didn't you hire your attorney?
Because she told me she didn't think I needed a lawyer for this, my lawyer, because this first time he tried doing this, he tried being sneaky and didn't send me papers for you. And so the lady contacted my lawyer to tell me I had court the next day, and she was like, she sent me it. She's like,
Who's your lawyer?
Michelle Giorgiano. She was only for my divorce though. So he told all the courts that she was still my lawyer. So the day before court, she got a notification that we have court, and she sent it to me saying, did you need me for this? She's like, did you know about this? I'm like, I had no idea. So she was like, you want me to reply back to that lady at your, the one that your assistant or whatever, to tell her that unaware? I said, yeah.
Who's telling you this?
My lawyer.
Okay.
But she wasn't hired for this. So he thought she was. So he thought he didn't send us paperwork that he was told and was supposed to do. So they canceled, the lady at your office canceled his first attempt as like, this is a game to him. Second attempt, again, this was supposed to be 2 weeks ago. She said he played along saying that I had court still, when I'm like, Mike, you knew I was going away when he planned this. So I called.
When did somebody down here tell you that you could change without going to court?
The lady that I went to file a motion for at the court system, the people up there have to file with.
When?
Let me see. Hold on, I can look right now.
I mean, is it a week ago or 2
No.
months ago?
I think about a month and a half ago. I have the date on these papers that I was filing. Hold on.
if it was a month and a half ago, then why did you just get the transcripts on August 29th, take her out of TK and transfer her to Edwardsburg? That was a week ago.
Yeah, Michael, I was getting the okay before I made any final decisions of moving down here.
You moved down there.
Yep, there you go. It was right before I moved down here.
Should have done that before. And Your Honor, with the first motion that I filed back in the end of May or the beginning of June, I made the mistake of sending her copy to her lawyer and not to her. So it became null and void. That was the issue with that. I wasn't trying to be sneaky. I just sent it to her lawyer thinking that's where I had.
As I would have expected that you would have, and it's not a big deal. And the lawyer said, no, you can't send it to me, so you would have had to send it to her, and you would have had to adjourn it probably to get her proper notice.
Yeah, so basically what I had to refile a motion, so and that was just for the money from the marital house. That was the first motion. That was back in June. I didn't make this motion until I had to be able to get her to school, to TK, to Middleville.
Have you ever talked to your daughter about whether or not where she wants to go to, and is she upset and this kind of stuff? Because this is a practical issue that how am I supposed to fix it?
Absolutely. And she's miserable down there. She is.
He's not. I have texts of brainwashing that he's been doing to her, and she did have a talk with him at first, and she told him she was okay with moving down here, and that's when he feel bad about her decision.
Your daughter at school right now?
Yes, and she's actually we talked to her. Then she had a real good day yesterday, starting to meet friends, and has a boy crush already.
What time does she get out of school?
At 2:30.
where do you live? Edwardsburg? How long does
Yeah.
it take you to get here to court?
It would take me an hour and a half.
All right, when did you talk to the people? See, the problem is you waited too long no matter what, because we would have been hard pressed to get you in, even to give you the chance to move your child, because we aren't just sitting here waiting for people to come in and ask for things. We gotta have an evidentiary hearing.
That's what sucks, is because I didn't know that. I'm looking right now when I went there.
I
Hold on.
understand, and I'm not holding it against you, but you also have to understand that you gotta play by the rules. And because you don't know the rules, doesn't mean that you're exempt from them. Okay, that's why everybody is supposed to hire an attorney, because they know the rules. And I can't imagine Ms. Giordano saying, no, you didn't have to file a motion to change down to there. I don't have any idea what would have been in her mind to do that.
I think I actually have an email of her stating that, because she asked, you said, do you want to hire me? I said, what do you think? She's like, I don't think you'll need me for this.
That was for that first one. I mean,
Yeah.
but
Talking about.
All right. I'll figure something out on this over the next few minutes, I guess. As far as the money for the house, you don't think you owe him anything?
No, I have actually, he owed more and I gave in to him.
You gave it.
I gave it as much as what he should have owed back. I didn't give back. I let that go, and it's in our text even. And I told
It's in our text.
yes, we have text before I cash that check with him, because we're going to go to court if he was not agreeing to the amount. I was not going to cash a check until we had an agreement of what was owed after calculations through the court papers.
Yeah.
So I made a statement. I said, Mike, before I cash this check and send you over this money, is it reset? Is this what, do you agree on this payment, this payout? He said, yes.
I never said,
I have a proof of that too, if you need me to send you the screenshots of that conversation, sir.
We're gonna have a hearing on that. You can bring your stuff in. If it's found that you owe extra money, I'm gonna fine you for it. If you find whoever's gonna lose is gonna pay the other person's attorney fees. Because this is a straightforward amount. It looks like you've got 50, just for round numbers, like you got $50,000 from the house. Medical bills were some, I don't know, 2,000. And also you were owed, ma'am, apparently about 8,000. Which would take it down to about 39,000, and you were supposed to split the rest. How is that? How's that not correct?
So it was 8,000. If you, the court papers was the 2,000 first out of the house sale before we split money. I got for, first before we even split anything for me for miscellaneous expenses.
Yeah.
And then after that, it was
It's in your judgment, and I can read it to you.
thank you.
I understand. Plaintiff shall receive the total of 8,100, which represents money defendant owes to equalize the value of stock in his name, the automobile, past due child support, and 2,000 owed to plaintiff for miscellaneous expenses. That's within the 8,000.
No,
That's
that's
what it says.
then I can contact her to contact you. No, the 2,000, he knows what I'm talking about too, because I even have the text with him breaking it down, extra
Okay,
2,000.
even if he owed you that 2,000, you still haven't paid half.
No, well, that 2,000 was supposed to be before we even deducted any of it out of the house sale. That was the 2,004. And then after that is when we divided what was left, the 47 after that.
47 after that, and
Was
you paid it. And he was supposed to deduct 8,000 out of that, so that came down to 30, I don't care, 38,000, okay?
And then go down here, the party shall divide remaining profits equally from defendant's portion. He shall pay plaintiff additional 220, which presents his portion of the late fees for the rent.
That's $220. Basically,
goes
you got
on.
38,000 to divide in half.
Yes, and then it goes on. And then on top of that was the defendant shall also pay the 240 from the check he wrote, which was actually 280.
Yep.
He left one.
Okay, but it's in the judgment of 240. So I'm down to, I don't care if I go down to $37,000 and it's split in half.
It still goes. And then we had medical bills we had to deduct. that
Those
we, I,
were already deducted. They were
no,
1,900.
that was deducted from when?
That was in his calculations. He's already got those deducted. 1,700 in medical debts.
Yes, that was not part of the 8,000. This was because we didn't have
I
that amount.
understand he deducted it also. All I'm saying is it looks like it's about, even with taking all your money into it is $37,000 divided by 2, which is some 17, and you only paid him 13.
No, 14, and then, but there's more deductions.
13
so-
for 36.
And then we both owed for the divided what we owed after the bank, after his check that he wrote from withdrawing from the bank, we had to divide in half the remaining balance of what that bank statement was that we owed.
We're
which was
gonna, we're gonna have a hearing on it. I'm not buying what you're saying right now. We'll see what happens. I'll set up an evidentiary hearing. You better either have attorneys or better have evidence, and you better follow what it says in the evidentiary hearing document. It says, file your documents and stuff ahead of time. And ma'am, if one of you is wrong, I'm gonna burn you.
Okay, I have it all right here broken down twice now.
Nothing you've told me would be convincing as of right now, because it's 100 here and 200 there. And basically there's 38,000 that has to be divided. And
Oh, yeah, there's the text, and then like on here too, it says he's owing $100 per month for his phone bill. He has not paid his phone bill since May.
I had to get a new phone because you shut my phone off, so
I finally shop in August when you weren't paying me
that's
still.
that's not in here.
has nothing to do with anything.
It's in about, it's F in section F.
Your Honor,
Yep.
so I didn't know how to ask. I would love to have our 16-year-old daughter's voice heard in this,
I'm gonna tell you what I'm gonna do here before too long on that. Okay, I'm setting up an evidentiary hearing on the amount of money that's owed.
Okay,
Because I'm not gonna be able to fix it here, because she says one thing, you say another. Looks pretty straightforward in the judgment. Like, there's nowhere near the amount of money that she's claiming she'd get. I'm just telling you, but I don't know, maybe she's right. As far as your daughter, I guess she goes to school on Monday, I'm sure.
Yeah,
Have her here at my courtroom by 4 o'clock today.
I'm not. Okay,
today I can't do today.
well, sir,
What is it you can do to follow any of the orders? That's what I'm trying to figure out now.
well, it is my weekend, Your Honor, and I'm driving an hour and a half to pick them up, but our youngest, Sophia, doesn't get out of school. She won't get home from school until about 4. So I was planning on leaving here at 3 or 2:30 to go down there and pick them up by around 4. But then I wouldn't get back here until
Yeah, you won't be back here till 5:30. I don't know
Yeah.
how it is that I'm gonna talk to your daughter. How am I gonna talk to her?
you could do a Zoom call after she gets out of school today, I guess. I'm not sure about today unless I go down there and get her out of school early and then,
But then you'd have to drive up here and drive back and pick up your other child and
yeah.
I'm gonna set up an evidentiary hearing on, what's called a, Lombardo hearing on changing of schools. I'll have my clerk contact you as far as contacting your daughter, trying to set something up. May have to be via Zoom, at some point. How long do you have her for this weekend, sir? Just till Sunday?
Yes.
I'm gonna set up something via Zoom. I don't know what, I'm not sure how I'm gonna do it.
Okay.
Set up a Zoom call with your daughter where nobody will be in the room with her, just me.
Yep.
And if I find out one parent or the other is trying to influence them, it is not gonna go good for you. This is a very troublesome thing to me. And if one person or the other is trying to influence her, to pick a school or something, it will not go good. I'll tell you that at the evidentiary hearing, it will not go good for that person at the evidentiary hearing at all.
Understood.
So I could have a Zoom call with her Monday. I take it right after school.
Yes, she'll be here.
I'll have my clerk contact you to set it up for Monday. Mr. Bauma will let you know when it is. You aren't gonna be allowed to hear what I'm gonna talk to your daughter about. It's gonna be between me and her.
Yep.
Ma'am, you understand the rules? I'm telling you the rules, not the clerk.
I-
or anything else.
I do now.
All right. All right, that will set up some hearings for you. Good luck. We'll see you.
Sir, after your talk with her though, will we have a hearing still too? I just want to know.
We're
You're
still gonna have a hearing unless Mr. Bauma and you agree to where she can go to school. I gotta have a hearing.
Okay,
Still gonna have a hearing about the money that is or isn't owed.
okay, I'm gonna plan on getting a lawyer.
I would suggest both of you do. I mean, it's just not. I
Yep.
Actually suggest the two of you act like adults and figure it out, but that isn't gonna work, so we'll have evidentiary hearings. Good luck.
Thanks.
We having hearings coming out of our butt. This is not the last one, I'm pretty sure.
No,
Jeez.
we're just starting our main duties.
All right, all the 9:30s, we're getting ready to start, yeah. Mr. Grabowski, can you hear me?
Yes, I can, Your Honor.
Good morning to you. We're just getting the others connected. You represent Mr. Or Miss Hamlin?
What? No, I represent Mrs. Majeski, Hamlin Majeski.
Oh, yeah, Miss Hamlin. She's still connecting. Mr. Ross, can you hear me?
I can hear you, yes.
All right.
There she is.
Yeah, but she's not connected audio wise.
Ah, I see that. Amanda, you need to turn on your audio.
I don't think she can hear you, but
Oh, I was thinking that was
because she has
just,
no audio, so you can't hear you.
yeah, I was thinking that was her mic, but I will,
There she goes. Miss,
there she
Hamlin,
is.
can you hear me? And if so, I see you're saying yes, you're, just so you know, you're muted at this point, so you need to unmute if we talk to you. This is the case of 12-8085 DS. Hamlin v. Ross. Both parties are present via Zoom, as well as Mr. Grabowski on behalf of Miss Hamlin, the plaintiff. This is the father's motion for parenting time, just says he wants 50-50. Just because you want 50-50 doesn't mean you get 50-50. What's Vadvarka to change any of the current situations, or what are you asking for? You how much do you visit now?
We have parenting time established between the two of us that I have an audio recording of. And Miss Majeski cut my parenting time without any explanation as to why.
What's in the court order?
We don't have a court order.
Okay, so you have some kind of a recording from when?
From my and Miss Majeski's meeting that took place back in May of 2023.
Doesn't mean anything unless you put it into a court order. If you have an agreed stipulated order, then it's one thing. I can't enforce something that you guys just talk about.
It was us going over a court order that we were supposed to be getting documented that never was documented.
I can't enforce anything. What is your current parenting time? What do you exercise right now?
with my daughters with Majeski, she doesn't allow me any parenting time.
When was the last time you saw him?
I seen Desiree last week, and it would have been last August. I don't know.
Over a year
June.
ago before
It was-
before you saw one of the others?
No, it was June, back in June of 2023.
Well, just apparently she has physical custody at this point. All right, and you have, in order to change custody, you have to show proper cause or change of circumstance. What is that proper cause or change of circumstance? Because she clearly has an established custodial environment and has done everything for the kids forever, okay? What is the change of circumstance to change custody? Because you're a 50-50 is not parenting time, that's a change of custody.
Okay, Your Honor, I don't know how the legal system works. I'm just trying to. be
I
a
just told
father.
you how it works. I just told you how it works, okay?
You're right. I felt.
So there is no proper cause of change of circumstance to change custody.
I'm just
I
looking
have
for
allegations
parenting.
that you only visited for 3 times as of 2022, I think.
And that is false accusations. I have recordings, documented proof of my visitations with my daughters.
Frequent?
The frequent documentation from the
Oh,
recording of.
frequent visits you've had over this is a case that's a 2012, so I'm assuming that, I mean, your kids are 14 and 11. And you're talking to me like, yeah, you saw them every other weekend, you saw them every week, what?
I seen them for about 2 months every week, and then Miss Majeski stopped the visitations.
2
I've
months
tried
every week?
visitation-
What do you mean 2 months every week?
I seen them weekly for about 2 months. Their practices, through Zoom calls, FaceTime.
Is, Mr. Grabowski, what's your response?
Well, our response is laid out in our response, what we filed. I apologize for the lateness of that.
I understand.
But in a nutshell, what Mr. Ross is speaking of is since during this summer, there were some limited video chats. We were in front of you, I believe, just about a year ago when Mr. Ross filed for change in custody. At the time, you informed him similarly to today, there hasn't been any change in circumstances or proper cause shown. So you suggested he work with me on establishing some parenting time because from 2012 until last year's hearing, he had seen the girls 3 times briefly. And so we did work with that, and I presented my client with a graduated plan, and she went over it with Mr. Ross. They met and agreed to try it out. And it started with some Zoom meetings with the girls.
4 weeks or something like that?
Yeah, it went, well, actually, the Zoom, well, exactly, it was for 4 weeks, but the Zoom meetings, I think there was 2 or 3 over the course of 3-4 days. And Mr. Ross would say hi to the girls, and then he'd turn it over to his stepkids or his girlfriend's kids or his girlfriend.
That is false. That is false.
If I may.
Sir, I'm gonna warn you only one time. He didn't interrupt you once.
I'm sorry.
You get your chance. If you interrupt him again, I'm gonna mute you and not be very nice.
I'm sorry.
Go ahead, counsel.
So Mrs. Hamlin contacted Mr. Ross and said, hey, this is, your kind of time, not for all these other people. And as our response says, things went off the rails immediately. Mr. Ross and his girlfriend showed up at the girls' games, which was okay, but things didn't go well. The day after Desiree, the oldest daughter, spent any time at all with Mr. Ross and his girlfriend, the next day she was suspended from school for the first time ever. conduct totally out of the norm. No idea where it came from. Des was received some counseling. Mrs. Majeski got her some counseling through Newaygo Community Mental Health. That went okay. There was allegations from Mr. Ross. He contacted my client and said, look, she's suicidal. We think she's suicidal. My client took Des, the supposed suicidal girl, to Pine Rest, took her directly there and had her looked at and said, does she need to be in here? Does she need to be admitted? Is there anything? Pine Rest told her, there's nothing here, and sent them on their way. We have found out that Mr. Ross's girlfriend has been, and Mr. Ross a little bit, but we believe it's mostly his girlfriend, has been surreptitiously seeing the girls behind Mrs. Majeski's back.
That's a lot of.
She's contacted the school
I
and
know
said,
there's a lot of allegations about her seeing the kids and stuff like that at the school or that kind of
yeah,
stuff.
she called the school and said she was their mom.
Yeah.
Told them not to take the bus home and she picked them up. Just improper. This is parenting time for
Sure,
Mr.
if you
Ross.
know that that is happening, and I'm sure you're gonna deny it, but if you know that's happening, that will not happen. Will not happen. If your girlfriend shows up and picks up the kids without the agreement of Miss Hamlin or your parenting time specifically, and she shows up and interferes in any way, shape or form, not only will I prohibit her from being around there, but I'll take that into consideration in any your time that you're gonna visit. This is your kids, yours and Miss Majeski's kids, not your girlfriend's kids.
I know that, Your Honor.
So,
But Mr. Grabowski, I'm gonna eventually, Mr. Ross is gonna get a chance to start having parenting time.
yes,
It's
we
not
agree.
gonna be a change of custody. He's not gonna get 50-50 because there is no proper cause or change of circumstance. But Mr. Ross is gonna be able to get some type of parenting time. What type of parenting time do you suggest at this point?
Well, at this point, as my client met with Mr. Ross this summer and they worked out this graduated parenting time, and as Mr. Ross himself says, they reached an agreement on it. It's just that within 2 or 3 days, Mr. Ross decided he didn't like the agreement anymore. I think that was appropriate for a dad who hasn't seen, well, the youngest, he left when she was a baby. He's got absolutely no relationship with her. As our response indicates, the oldest, Des, who has, she has an IEP at school, so she has some issues. She is scheduled to start counseling with a Mr. Hyde, and we detailed him in our response on the 18th. My client has been trying desperately to get her in to see someone like Mr. Hyde, who has a great reputation in that
Why
area.
don't I send this to the friend of the court for a parenting time evaluation? See what the friend.
That would be certainly very appropriate, Your Honor.
I'm gonna send this to the friend of the court for a parenting time review. They will interview both of you unless you decide not to, in which case they'll only get one side. And they'll make a recommendation as to what's appropriate for some type of parenting time. Do both of you work?
I do, yes.
Well,
I don't.
because it's a cost of $150 per person to go to the friend of the court. Is there any reason you can't afford that?
No, Your Honor.
No.
All right, then we'll split the costs, 150 each. You'll be paid, I believe it's within 14 days. You'll get notice of it. If you don't pay it and the other person pays it, it's not gonna go good for you. I mean, I sit here, I'm the one who makes the decision. And you just both told me you can pay it. Now, if you don't pay it, you're gonna come back to me and say, why? And you gotta understand, I'm the one who's gonna make the decision on the parenting time ultimately. And I don't know why you would wanna tell me you're gonna pay it and then not pay it, okay? I'm gonna take that as credibility. So you will each be responsible to pay that. You'll each be responsible. The friend of the court will contact you. They will talk to you. They will do whatever is appropriate. And we'll get a report from the friend of the court. Cooperate with them 100%. They'll send out a report. You get a chance to look at it. If you don't like it, you can file objections to it. Mr. Grabowski knows how to do that, but I'm just talking to you, Mr. Ross. If they make a suggestion and you don't like it, you can file for a objection to it. We'll have a hearing and all that kind of stuff. All right. Work with the front of the court. They'll try and get to the bottom of things. It probably will be some kind of a break-in time. I don't think they're gonna probably just say, oh, no, I'll go to every other weekend or something like that. But I certainly trust their abilities to review everybody's situations. You'll get a chance to provide what they talked about. They do this all the time. Any questions, Mr. Ross?
No,
All right, Mr.
I'm good.
Grabowski, Miss Hamlin through Mr. Grabowski, any questions? She can always ask questions of you.
Right, no, we don't have any questions, and we appreciate your time this morning.
Ma'am, you got to cooperate with the front of the court, sir. You got to cooperate with the front of the court so I can get a better idea of what's appropriate. They'll take into consideration kids' special needs and all kinds of stuff. Good luck. We'll get that. We will do the reference. You don't have to do that, Mr. Grabowski.
Okay, thank you.
Okay, make sure that you pay when you're supposed to, and we'll get that notice out to everybody as soon as we can. Good luck.
Thank you.
Have a good weekend. Thank you.
You as well.
Can everybody hear me?
Yes.
All right. We're here in case 21-3312 DM. We have Ludwig versus Ludwig. Both are present via Zoom as well as their respective attorneys. Ms. Bryan for plaintiff mother, Ms. Van Tol for defendant father. Starting to become frequent flyers in the court, and I am well familiar with this case. This is a motion being filed by Ms. Van Tol on behalf of the father for a change of custody, going through, I don't know how many pages of 16 pages of complaints and whatnot of what a horrible person mother is. I got an answer from you, Miss Bryan, telling you what a great client you're and what a deadbeat the dad is. That pretty much summarizes it as far as I'm concerned. Miss Van Tol, this is, I'll tell you right up front. I believe there is plenty of proper cause or change of circumstance to look at legal custody. These parties don't get along. I don't think they could agree if that today was Friday. So I think we should have a hearing about legal custody. The only question is, what do I do about physical custody? Miss Van Tol, go ahead and make your anything you want to add. I mean, I've read page after page of this garbage.
You know, Your Honor, I understand the court's frustration with the continued issues in this case. Ultimately, I think the issues revolve around an inability to move on. And I'm just not sure how we can impress upon Ms. Ludwig to move on. My client doesn't want to rehash the past. He wants to move forward.
But he doesn't, but you do in this motion, you rehash the past.
Well, we have to. I mean, right? We're filing a motion to change custody. The motion to change custody is necessitated by the fact that Ms. Ludwig continues to stalk my client.
Is it necessitated by the guy who isn't even part of this, who says, I don't even know these people, and you're getting a PPO against me because you think you're doing this?
Sure. So let me address that. I'm happy to address all of those things, Your Honor. So thank you.
You're not going to address much of them here today.
Sure. The PPO was filed. The PPO was supported by my client's statements, the neighbor's statements, and the statement of Miss Meager's friend, who also witnessed this gentleman in Ludington in the summer of 2022, taking pictures of my client's child and Miss Meager on the beach. My client approached this individual. Looks very similar to Mr. Thielen, okay? The issue in this case ultimately stems around Miss Ludwig has told Mr. Ludwig over our family wizard since January of 2022 that she has people watching him. She has a coworker living in Miss Meager's neighborhood that's sending her pictures of my client's vehicle at her house. She then goes ahead and tells Mr. Ludwig that she hired a PI, sends him a bunch of messages in March of 2023 showing pictures of my client and the child, vehicle information. Every single thing has continued on because Ms. Ludwig can't move on. And that is a problem. This is not just the only issues, right? We have the issue at the baseball game where Ms. Ludwig shows up. She makes a huge scene in front of the minor child. I have video of it, Your Honor, and I'm happy to provide it to the court. Ms. Ludwig does reach over the back seat well, I shouldn't say back seat.
Well, look, I'm gonna
Mandy's
tell you
sitting in the
right
front
now-
seat.
I'm gonna tell you right now, that Miss Ludwig's apparent being drunk at a kid's baseball game, we can get rid of all of that and that neither party can show up at the other party's times, okay? So that he can't show up when she takes him to baseball games and he can't show up there. That's the only way I can keep these people apart.
But is that really what's best for the minor child in this case? Because he wants
but
his
the-
dad to
but
come
the
to his
part-
events,
no,
but
but the
whose fault
part-
is that?
Parties can't get along.
Whose
And I'm gonna
fault
have a
is that?
hearing. I don't know.
It's not my client. I can tell you I've seen the video,
I'm
and
sure.
ultimately that's an issue. And I don't know what to do about it other than she can't be calling my client and his girlfriend names in front of this child where the child's then having to say, don't talk to my dada that way. Don't speak to my dada that way. That is horrible. What is my client to do? She gets out of a freaking car at an exchange last Friday, starts taking pictures of his vehicle and the boat that he has attached to the vehicle. Again, just to spur controversy. She shows up at Metro Women's Health. She has no idea my client's there. I don't even know how she knows this summer, and leaves Crew's sippy cup right outside his door just to let him know that she knew he was there. Then she messages them on OFW saying, how are we going to speak to Crew about the fact that Mandy's pregnant? She's not pregnant. She is obsessed with my client. I don't know how to get over this because it is impacting Crew, who is now in play therapy every week. And I understand she wants to say it's because my client alienated, but that's not the case. My client
Well, you
hasn't.
know,
Miss Judd didn't find
Right.
it.
I'm gonna give Ms. Bryant just a real short time to respond because I basically know what I'm gonna do.
Okay.
Ms. Bryan, I'm sure you're gonna deny a lot of this stuff and say that, a lot of it's untrue and blown up and all this kind of stuff. I mean, I read 25 pages, okay? If everybody submitted this much on 40 motions for today, I wouldn't have even been able to read it all, let alone have a hearing on all. And so you can respond, but my opinion is, after reading everything, is that definitely we need to have a hearing on joint legal custody, because I think that is clear that there is proper cause or change of circumstances, because these people cannot get along. Okay, they are not going to be able to make joint decisions together and for the best interest of the client. I don't know who will end up with the legal custody. I have no idea. Okay, and I think as far as proper cause or change of circumstance for physical custody, I intend to have an evidentiary hearing to determine if there is proper cause or change of circumstance to move forward with that. You can have a threshold hearing that I will set in here and determine if in fact the threshold is met. If Miss Ludwig is doing half the stuff that she's alleged to have done, I'm probably going to find that we'll have an evidentiary hearing regarding custody, but I'm not going to determine it right here today because I get so many things going back and forth between everybody. I'm just going to have an evidentiary hearing to determine if threshold is met. And then from there, if threshold is met, we'll have an evidentiary hearing on custody. But
My only concern about that plan, Your Honor, is that when you do the threshold hearing on the change, I'm sorry, on whether there's a change of circumstance or proper cause. These parties are gonna dig in both ways. And, we'll have our claims, he'll have his claims, and it's just not helping the child.
No,
mean,
but
if we're-
but I can't do anything else. I'm not gonna, my
I-
only other choice here is to say there is or is not. Threshold is met, and I don't trust, I'll be honest with you, I don't trust either party very much.
I think the court has the ability, based on the pleadings filed in the response, to determine whether there is a threshold change. For example,
I
we
do
know,
have the ability to, but I'm choosing to have evidence brought in, and I'm not going to have a long hearing. I'm gonna tell you right now, you're gonna come in and present. Because I don't have time here today to really go through all this stuff. And I thought about
Okay.
giving you guys a separate time to really go through this, but I got 40 motions today, and I just don't have time to go through all this. So I'm gonna have a threshold hearing. We're gonna have a short threshold hearing. It might be an hour, it might be 2 hours. And believe me, counsel, we will meet beforehand to find out what kind of documentary or exhibits or something like that is gonna put in. We're gonna figure out what is gonna go in and what isn't, what there's an objection to or not, and maybe decide who the witnesses are. We're not gonna go through a custody hearing. We're just gonna go through a threshold hearing. And probably each of the parties can testify. And I'm gonna set limits on this, okay? I'm just warning you right now. And then we'll see what happens. And then I'll make a determination whether there is or isn't threshold. You
Your
know,
Honor,
I've already found the threshold on legal custody.
is the court going to refer the matter to front of the court for the issue on legal custody?
Nope.
Okay.
Because it'll just take time for them to go over there, and I guarantee you that whatever the friend of the court finds, the person who isn't happy with it is gonna object, and I'm gonna have the hearing anyhow. I guarantee with the two of them and there's just not, if they say legal custody should go to Mrs. will object, and vice versa. I know that. So it'd be just pushing it down the road extra months, so that then I'd push it farther down the road. At the rate we're going, we won't get through custody and everything until January. Because I gotta have but I can have a relatively quick threshold hearing, and that's, believe me, that's relative to something. Because I'll probably only give like 2 hours or something, one to each, but we will meet ahead of time to get through stuff that's appropriate.
Okay.
All right. I mean,
Thank you, Your Honor.
that's the way it's got to go in this case. And I'm probably gonna wait and set up the legal custody determination after I have the physical custody threshold hearing, so that I know what's going on with that. But we will have an evidentiary hearing ultimately regarding legal custody, because these parties cannot get along.
And Your Honor, if the court finds that the threshold is met, will the court grant leave to allow us to file our own motion for change of custody?
If threshold is met for custody, okay, you don't need to file one. Because it's a custody hearing. I mean, people have made mistakes before and filed for custody and actually lost what they think they were gonna get. Once custody is an issue, I'm not gonna say that he can only win. It won't change. If you, during that whole time, show that custody should be with her, I don't see any reason why I can't change it to her.
Right, thank you.
Anything different, Miss Van Tol?
I don't. I think custody, if it's in dispute, it's in dispute. I get that.
If I find there's a threshold, I think it's in dispute, and we will do all the custodies then and figure out where all custody should go.
Got it.
All right, so I'm telling you right on the record, you don't need to file. Unless I suppose if I find there is no threshold, and then you decide you want to file and say there is threshold, which won't do you much good, but I'm assuming that everybody's going to try and find threshold. That the two attorneys need to sit down and talk about as much as you can on this to streamline this stuff. All right, because we're going to be at this forever. All right, and both of you need to talk to your clients and be realistic about some of this stuff. You both know what you're doing.
Understood.
And ma'am, you need to listen to Miss Bryan and Mr. Ludwig, you need to listen to Miss Van Tol. Seriously, listen to them on what's going on. If because this child is 3 years old and is in therapy, that is awful. And I don't know whose fault it is. It's probably some of everybody's fault. So figure it out. We'll send out notice about the threshold hearing. I'm gonna hold off on setting the legal custody hearing. I will find there's threshold for that if somebody wants to file an order that says the court is found threshold is met for legal custody. You can do that, but I'm not going to set that right away for the reasons that I've told you. I think it's appropriate.
Your Honor, is it possible for your clerk to reach out regarding scheduling of this before it's scheduled?
Absolutely not. She's going to set it and hope that you guys are around.
You said set notice, and I was like, well, maybe if we can get, some advance.
We're gonna try and make it impossible for both of them.
Thanks, Judge, I appreciate it.
Let me, I'm assuming that you will check with your clients promptly to see if they're gonna be out of state or something. We will check with you. I'm gonna tell you that Miss Dewey gets really tired of checking with one and another, and one person can do this and one. If you get it, you're gonna get about 2 chances and then she's gonna set it, but we will really try to accommodate your schedules. It'll probably be a morning or an afternoon for the threshold, so
Okay,
we'll do the best we can.
I appreciate that.
And believe me, she will work really hard with you, all right?
Thank you.
Anything else?
No,
No,
thank you.
All right, thank you very much. Have a good weekend. Take care.
thank you.
Thank
Bye.
you. Miss Bryan, I think.